announced the other day in the hallway. You're singing "Oh Happy Day."
One word prayer. Justice, where are you?
Hey, partner. Happy. Here's what I've crafted. Happy MLKB Day. See what I did there? MLK, LKB. So yeah.
Good, very
yeah.
good. This is Martin Luther King Day. We should all remember it. Very important person in the history of our country. Just amazing, becoming more amazing in terms of civil rights and our country and everyone's rights as we go along. So please, I hope you went to some memorials. I hope you read something about him because that's what we should concentrate on to unite ourselves. And it was also Inauguration Day.
And it's a 3-day weekend.
And it's a 3-day weekend.
And that thing. For some folks, we really weren't going to do much. And then we got these new trials that are starting up. And I thought it'd be a good idea just as a primer to kind of talk about what they are, where they are, what's happening. One on the West Coast, one on the East Coast. And so that's what we shall do. But yeah, I hear there was a new president inaugurated. So
yeah, primer. Okay, I like that.
Okay.
Primer. Yeah.
Okay, so class, let's start with ASAP Rocky. Okay. Here's the deal on this. Obviously, ASAP, not a real name. And the dollar sign replaces the first S. I'm sure you're aware now. This is Rakeem Myers. I say Myers. Is it Myers?
You because apparently my Alexa is having a reminder to get ready to discuss these cases. Okay. So if you hear her again, that's Alexa. She's in the class.
What did she say?
She said, "This is a reminder. Get ready."
Okay. All right. So is it? I want to make sure I pronounce his name properly. Is it Mayers or Myers? Mayers. Mayers.
I looked it up, and I heard two different people. I've heard all sorts of news.
That's what I've heard too. So okay, we'll have to wait until Joe Tacopina says it properly.
I should have asked him. Joe. Just for disclosure, Joe Tacopina and I are friends. We spent the first week in January this year and other years together at Harvard Trial Advocacy Workshop. And the last thing Joe and I talked about is we were having lunch the day before we both had to leave, and he was leaving Friday to go to California. He says, "Yeah, I'm leaving out tomorrow to go try the ASAP Rocky case." And of course, I wished him luck, and never thinking that, of course, we were about to cover the case. So I do want to make that disclosure.
Well, your life is like Severance. So, you have two different, totally separate lives, and that life didn't cross over into this life. I met Joe once. Anybody remember the Melanie McGuire case? This was the fertility nurse in Jersey that allegedly, now has been convicted of killing and chopping up her husband.
Raising hand.
Yeah.
Raising hand.
So he lost that case, but what an amazing case that was, and I'm working on a follow up to that. That's all I could say at this point. Joe wouldn't recognize me or remember me from a ball of mud, but it was. Oh, am I calling on you?
Yeah, you are, because it's a New Jersey case out of Middlesex County, and I believe Joe Tacopino consulted with my husband at that case.
Was he retained?
I don't know, because I asked after we discussed about whether to do this case. I asked him, and quite frankly, Michael's had so many cases. I mean, his office would have to look it up. So
I'll have to check my notes from get my box of stuff from. That was one of the cases I covered when I was with Court TV, and I don't remember him testifying, but
just retained.
Anyway, so he's.
Experts are in all these cases we talk about. All people that, why don't you have an expert? A lot of experts are retained to consult, but they never testify because their opinion either is not favorable or they're retained to advise the attorneys. And I retain experts all the time. How do I cross-examine? How do I do this? What do I do this? Or to train me. So
yeah, just to learn. Yeah, and as I've always told, prospective experts, don't give me a written report. I'll tell you if we need you for that purpose. Don't give me one, because the moment it's given to me, it's discoverable by the other side, and for better or worse. So anyway, that's the connections with Joe, and lovely Joe. I'm sure we'd love to reach out to him after the fact and see if we can get some update on this. But we have some of him in action. Now, this is what's going on. This was a pretrial hearing that was last Friday. This is just typical housekeeping. Okay, you got Judge Mark Arnold, who I think you'll like. We'll see him in a moment here. And there's an interesting cast of characters in this case. The bottom line is Mr. Rakeem, I'm going to say Mayers until I learn otherwise, ASAP Rocky, is accused of shooting at a former friend, business associate in the rap world, Terrell Efron, who is also known as ASAP Relly. And so they got in an altercation one night. It was in November 6th of 2021. 3 or 4 shots were fired from a semi-automatic weapon. Prosecution says that was ASAP Rocky. And the injury, this is an assault case, felony assault, 24 years max on the 2 counts. He got his knuckles, ASAP Relly got his knuckles kind of grazed by the bullet. So obviously an assault's an assault's an assault. You can't minimize the injury. The assault is the crime, right? And the actual firing of the weapon. So that's where the case stands. And some of the names you're going to remember from this case. Obviously, we talked about Joe Tacopina. How about the new prosecutor just added to the mix? John,
you were the one. Let's put this out to our class. Does anybody know who it is? Because I did not know this until my partner here, Michael Bryan, who researches everything. I mean, next time I have a murder case, I'm hiring him to be.
Thank you. I could use the job. Got enough hours at Home Depot.
And let's see. Let me class. Let me go back to my saved voicemails. Okay. Let me just do this for a second. Save voicemails. And I was looking through them the other night for something else. But does anyone, while we wait, know who the new prosecutor is that's been assigned to put on the case? Come on, class. Come on, people.
And I think it's interesting. We will see him in this little clip. I think it's interesting. He's officially the number 2, but I can't envision this guy being number 2 to anybody, having seen the show he put on, of course, in the Durst case. You might remember the Durst case.
That's a hint. So who is this? Pop quiz? Who is it?
Okay, well, we're gonna show the video now. And again, this is from that hearing. This is really basically the whole hearing. And again, they're doing some housekeeping. We'll stop and start along the way because I think there's some interesting things that we could chat about that came up as they were going through the housekeeping. Of course, that means I need to find it here. So.
Here's some drama. What was the question? The question is, who is the new prosecutor that's been added to the ASAP Rocky case as allegedly prosecutor number 2 in Los Angeles?
Okay.
Get the answer.
So there's Mark Arnold. Still behind the sneeze bars. Like I don't understand that, but it is California.
Mayors, PA 508142.
See, now he called him mayors. Okay.
For Mr. Mayor's Joseph Tacopina.
And Joe Tacopina said mayors, so I'm going with mayors.
Paul Preslemick and John Lewin for the people.
Who?
So it's clear, Your Honor.
Do you hear that?
All right, could you go back? Who was it?
Yeah, it's kind of echoey because they're not mic'd, and so the room is kind of mic'd. So I will take it back just a second here, so you can.
It's the answer.
I won't talk.
Paul Preslemick and John Lewin for the people.
Just so it's clear, Your Honor, I'll be joining as the second lawyer on the case for the district attorney's office.
Okay, John Lewin.
We've had some discussions off the record that I want to put on the record. I understand that there is a settlement is not out of the question, but there has to be some discussions between both sides. But it is more likely than not there won't be a settlement, but it's possible. Is that correct?
From our side, we have no interest in a settlement. Our client has not indicated he's willing to take anything, but obviously I will listen to anything, any offer, and I have an obligation and duty to relay it to my client, which I will do.
All right.
And I think just so it's clear, Your Honor, what we wanted to do, given that the defendant, if he's convicted, even at midterm, is looking at years in state prison with at 2/3 time, we wanted to make sure that before he ends up going to trial, that he understands what we would be asking.
Well, I'll do that on the record when on Tuesday.
Right, and I just wanted to clarify counsel's comments. So we, in response, indicated that, okay, if it's worth us checking to see what an offer would be on this case, we'll do it. Counsel indicated that it is definitely worth doing that because his client needs to be made fully aware of what his options are, and that's what we're doing.
All right. We're going to have to do the case in Department 102.
Okay, so just to recap what's going on there, there's a suggestion there may be some plea deal. Tacopina is saying, and no way, ASAP Rocky is not interested. Of course, I have an obligation to present any offer. I'll listen to it and present it to my client. I have an obligation to do that. And then John Lewin, who's number 2 on the case, his number 1 is sitting next to him. He said, these guys got to realize it's 24 years on the table. 2/3 would be served. That's 16, as my math holds. And so, yeah, there may be something we're going to put into to a plea. They have to understand those are the hard numbers. So he's, Lewin, as usual, is already trying to put a defense in a headlock, saying, look, this is the reality. When we get a conviction, this is what your guy's facing. So you might want to listen to a plea deal. So
it's actually interesting. So I went back, and here it is. Okay, I don't know if you can get this.
Oh, wait, let me see what you're doing. Hold on. Let me get that opened up here. So what are we looking at?
I got to move this way. Okay.
There you go. What are we looking at? Turn it.
There it is, John Lewin. Last time I spoke to him was around when he called me. I missed the call, July 2nd, 2000.
Okay, give him a call. It's about 3:10. Just fire it off.
Well, we make it. John is not. John will give you, if we say something that John says is incorrect, he is not adverse to giving us.
I remember he was very mad at Law and Crime over the course of the trial.
Oh, I can show the number. It's okay. I can show the number. Did I show the number?
I don't know. Somebody might grab it.
You can call him, and it's, if you look at the things, they find him at his office. So it's not like it's a secret number. Anyhow, so yes, I mean, and you really talk about headlock. Yes, he said, okay, so we want to discuss settlement. Well, settlement means plea deal. It doesn't mean settlement, right?
No, there's no money changing hands. It's a deal. How long does your guy want to go to jail or prison?
Yeah.
That's
and therefore and Joe knows he has an obligation, so he has to have an obligation to listen. But what he's trying to now, in my opinion, kind of manipulate this to say, all right, because you're going to listen to, because people don't understand, you have to bring every offer.
Of course.
Client. Yeah. Because you're going to listen. Maybe your client is guilty, because why would you be listening? Why would you take that pardon unless you're guilty?
That's a whole different story.
But what everyone understands is that, so I don't want to settle. I'm telling the prosecutor, I don't want a plea deal, right? I'm innocent. Prosecutor comes to me with the deal, puts it on the record. I still have to bring it to my client, whether or not my client's going to take it or not, or is interested, or is saying not guilty. So it's kind of a little bit of very smart on his part, but also very smart on Joe's part to explain the ethical obligations.
Yep. And interestingly, it was the judge that used that term settlement. So let me see if I can pick this up where we left off. Hold on here. I will try. I think right about here somewhere.
What I would like you all to do, though, on Tuesday, which is the 21st, to come
tomorrow
here first to this courtroom.
Housekeeping.
If you could be here at 10 o'clock, we'll have a jury panel. Is it 10:40? It has to be 10:45?
The jury seat.
10:45 out in the hallway in front of Department 102. We're going to tell the jury that it's going to take approximately 15 court days. Does everybody agree with that?
Yes, Yes.
All right. As far as jury selection is concerned, I will discuss I will let the jurors know that regardless of who a defendant is, whether they're the richest person in the world or the poorest person, everybody is to be treated the same. Nobody is to be given brownie points or lose brownie points. I'm just using the word brownie points just as an illustration.
So you mean they're not real brownie points? Come on.
In life, everybody has to be treated the same. If the evidence proves a defendant guilty beyond a reasonable doubt, I'm going to tell the jury, your job is to vote guilty. If the evidence doesn't prove guilt beyond a reasonable doubt, your job is to vote not guilty. And I'm going to discuss with the jurors the various levels of proof, preponderance, clear and convincing evidence, and proof beyond a reasonable doubt. I will also talk about the fact that the charges are not evidence. I'll talk about the burden of proof. I'll talk about the presumption of innocence. I will ask the jurors whether they or anyone close to them have either been accused of or been the victim of a crime of violence. I'll ask them if they are aware of or do they know either the defendant or who is it his girlfriend?
Okay, let me tee this up for you here. We're about to talk about Rihanna. Okay, Rihanna, who is the partner of A$AP Rocky. They have 2 kids together. They've been together for a long time. They are not married, and that's going to be critical. Let's hear the judge analyze this.
His wife.
How
I mean, it's his common law wife, Your Honor. They have
It's
2
com-
children
right.
together, so
all right. So I should characterize it as common law wife?
or just wife. It's fine. However you like, but yes, they're
No,
not. I mean, they're a common law husband and
I'll call
wife that
her
live together.
whatever you want me to call her. You want wife? Okay.
Sure.
Your Honor, I think if they're not legally married, we prefer that she not be referred to as his wife and that she is just referred to as his significant other or mother of his children.
Are they legally married anywhere?
I don't know,
All
but
right.
certainly
If they're
they're a common
legally
law
married-
husband and wife.
If they're legally married anywhere,
Yeah.
there's no common law marriage that's recognized in
Just
California.
call what you want. I don't, whatever.
Okay.
It's okay.
If they are legally married anywhere, she will be his wife.
Okay.
If they are not legally married anywhere, she is his
Significant other, okay.
All right.
Thank you, Your Honor.
Okay, so first of all, let me ask you, Joycey girl, do they have common law marriage in Jersey still?
There's common law marriages everywhere. However,
No, it's not everywhere. It's almost nowhere.
no,
Like in California, it's not legally recognized. I'm just wondering because Joe was making it sound like it.
and Bob Bianchi will agree with me on this, but everyone's using it to say either you have to recognize it because everyone believes in the common law status, right? Especially now that in Jersey, you have 2 types of marriage. You have a marriage, you have a civil union, and Jersey has both civil unions and marriage, and therefore, you should be one or the other. But everyone, when you talk on the street, talks about common law wives.
Well,
If
yeah,
you-
because it's an ignorant thing to talk about. Even the judge realized, dude,
Well,
you don't have it anymore. Tacopina made it sound like, of course, it's a common law marriage. So that's why I wondered if in Jersey they still have it on the books there. Do they?
Well, he's from New York, but look at Goldie Hawn and
Kurt Russell. They have a relationship. But why is this important anyway? I mean, why do you think the judge is bringing it up? Not just
it has to
because
be admissions or statements or something that they want her.
there's no privilege.
Yeah, there would. Well, I'm going to argue that there is privilege, even though there may not be privilege. Okay. Why do
Okay.
I know. The classic lawyer's answer. Let's go back. Okay, class. Let me have you, the student. Privileges are set by what? Either 1 or 2 things: statute or court rule. Okay. All right. You got that right. Michael. Statute or court rule. All right. I give you 100 on your test.
I'm the class. Okay, I'm
You're the
sorry.
class. Statute or court rule, right? Usually privileges and statute usually has to do with statutes. It's usually in the federal court, the federal statutes. Do you know that, for instance, that unless there is a court rule, whether it be in federal courts or state courts, for a psychologist privilege or a medical privilege, there is no privilege? We all take it for granted. Oh, I told that to my doctor. It is privileged. My doctor cannot go out and say anything. Well, that's true if there is a court rule or statute in your state or in the federal jurisdiction that gives it a privilege. And usually it has to do with some kind or other kind of rules. And in federal, there could be other rules besides court rules. Okay. There could be agency rules, but or else there is no privilege. And that court rule, that could be taken away anytime at all. And we saw it in domestic violence cases. Remember, if you were a domestic violence victim and there was a court rule that said there was a privilege between husband and wife, you couldn't testify. But along came the states and said, hey, no. We're either taking that out of the court rules or we're going to have a statute that says, of course, you can testify against a person that just beat you up, even if it's your husband. Yeah. So does that answer your question about what
So
privileges are?
yeah, and in this case, first of all, Rihanna is not expected to testify, but she can, and there would be no way to assert a privilege as a result because they're not married. In most states, it's codified. They're very simple. It's doctor-patient. It's mental health provider-patient. It is attorney-client. I mean, there's a clergy, penitent. You don't have one with your accountant, generally. You don't have one with your gardener. And quite often, the discussion has to relate to the reason those people are in that relationship with you. So if you're having a conversation with accounting with your doctor, probably not privileged, right? So we'll see. The judge was concerned as whether or not she would even show up to watch, because that could be a disruption, which I think he may get into here. Let's go back in.
Before we get into it, how is the state of California going to get jurisdiction over Rihanna, who's in New York, to come to California to testify against her common law husband?
If she wouldn't voluntarily come, how would they subpoena her?
Right. Anyone? Okay, you know what? Let's put that on the burner. We can answer that. We can get the answer on the next classroom, the Brian and Baden Just to Serve TV classroom, because it's very interesting and very complicated.
Okay, here we go.
I will also consider asking going to additional areas with the jury, the prospective jurors, upon hearing input from both of you, if you can think of areas that you want me to go into. Once I'm finished, both sides will have a very good idea of what's in the jury box. I'll only talk to 12 jurors initially. Each of you will have an hour to talk to the original 12, and then each time the juror is excused and replaced with a juror, you'll have 5 minutes with that one juror. Our jury trial hours will be 10:30 to noon and 1:30 to 4 o'clock. You're welcome to have any non-alcoholic beverages on council table.
How about snacks?
If during the trial you feel the need to approach a witness to show them an exhibit, or for some other reason you feel the need to approach the witness stand, you don't need to ask permission, just do it. Because 99.5% of the time the answer would be yes, that you can, so I don't see the need, of the formality of, that you have to ask permission. If a witness needs to refresh their recollection with some type of a document, you don't have to ask permission whether it's okay. It will always be okay. So just let them refresh their recollection with whatever document.
Stop.
Isn't that interesting? It's a very loosey-goosey courtroom, right?
Actually, I kind of like it because it saves a lot of time, right? But classroom, Michael Bryant. Okay, classroom. Another question. The Bottom Bryant classroom is now open again. Refreshing a recollection with a document. Do you only have to refresh recollection with the document? Is that the only thing you can use?
No, you can use anything once you've established that they don't recall whatever it is you're asking them about, and that they can then review it privately before. They may never even say whatever the document is or what it includes or the video. As long as they see it and it refreshes their recollection, then they testify with that refreshed recollection.
That's right.
The item being used is not entered into evidence.
As I teach people, you could bring in the kitchen sink, your kitchen sink. You could bring in my phone. You could bring in anything. I could bring in Toby the poodle. If that refreshes their recollection, it can be used.
Yeah. So let me ask you about in California, we used to use what's called the 6-pack for the jury. So you'd have 12 in the box and then 6 right in front. So you're dealing with 18 people at a time. I always use the Post-its on a board, because I'm sure there are some crazy apps now that do the same thing, but I love just the Post-its. And, there goes Miss Smith, you're out. Mr. Jones comes in. So this guy doesn't do that, though. He just has 12 in the box, doesn't put the other 6 in front. I get the feeling tomorrow's jury selection is going to be very quick and efficient, and that he's going to be moving people in and out as quickly as he can. And he just said the attorneys get 5 minutes with anybody that he has left in the box. What do you think about that process?
Well, you better talk fast. I mean, all I can say is, anyone from New York City can talk, or New Jersey can talk really fast and get a lot of questions very quickly.
Okay. And what was the other thing he said? Oh, yes. I don't know about snacks, but you can have any non-alcoholic beverage.
Yes.
I love it.
Oh, regarding what we talked about, discovery, I understand the people have fully complied with Penal Code Section 1054. What I have directed the defense to do is their witness list consists of What's the total number of people on your witness list? 30?
I think it's 34 year, I'm sorry. I think it's 34 year honor.
You mentioned that it's your intention to not call many of them, but
Yes.
what I directed you to do is for those witnesses you know you're going to call, or you reasonably know you're going to call, that you are to provide complete discovery, any written statements, recorded statements, any statements of any kind to the prosecution. For those witnesses that you're not sure of, I want you just to provide a paragraph summarizing what they would say if they did take the stand.
Sure.
You know, although the witnesses were not named, the court had indicated, when counsel said there were two
Yes.
witnesses, that those two witnesses are to be provided the full discovery now.
Michael.
Wait, has that been provided yet or not?
No,
how did he-
Yes, yes.
Mr. Lewin, I thought John Lewin was the second counsel,
Oh,
like
yeah.
co-chair. He's the only prosecutor that is now speaking, especially to the judge and with Joe Tacopina or at Joe Tacopina. What's up with that?
I don't know. Wait till this. There's one more nugget I want to use before we move on to our next case, and it has to do with the handling of witnesses. Now, we know that most judges will tell attorneys, look, if you have a team, I don't want to hear from the whole team. When whoever's doing the witness also will object when that witness is cross-examined, right? Pretty normal. Well, watch how this plays
no,
out.
but it is to be
They have,
provided.
but we'll get to them, but they do have.
Can you do
Yeah,
that
no
in
problem.
the next 24 hours,
Sure.
provide them full discovery of the people that you know you're going to call?
Yes.
Thank you.
All right.
Your Honor, speaking of which, apparently, now I'm communicating with my office in New York, Mr. Siegel's been in touch with Paul, and apparently there are two witnesses on their list, apparently that we don't have any discovery from, and there's been no summary of what their testimony will be, either Vivian Gonzalez and Patrick Marr.
That's not true.
Vivian
not
Gonzalez
true.
and Patrick who?
Marr,
Spell it.
M-A-R.
They are both employees of the Orange County Regional Computer Forensics Labs. They are the technicians that imaged or duplicated the defendant's cell phone. So the defense has been provided a full Cellebrite copy of the defendant's cell phone and the reports associated with that extraction, which is where what they did and their statements are contained, was also provided to the defense.
Do you have-
So Vivian's and Patrick's statements were provided?
Yes, their reports
Provided to who?
to the defense.
Okay.
To Mr. Tacopina?
Yes, they're his
Our
office,
office,
him, Miss Kaplan.
Did
yes.
you do it, Mr. Perslomiak?
I would have to look at the discovery receipts. I know it's been turned over to them, but that may have been provided by Mr. Engel prior to my involvement in the case.
All right, I'm going to assume that it has been turned over. If for some reason you don't have it after
We don't.
a due diligence search, then we'll revisit it.
Okay.
You know, one question regarding objections. I've seen the courts do it two different ways when we have multiple lawyers. One
Oh,
way.
thank you for bringing that up, and I was going to. It's one lawyer per witness.
And the question I would have, Your Honor, is in terms of objections, can it be designated, and it'll be designated in advance? As an example, let's say that I am questioning a witness on direct, but that my co-counsel is going to handle the objections. In other words, my understanding is, unless the court controls.
No, why does it have to be that way?
Well, depending on what the witness is going to be, we might tactically decide that the non-questioning lawyer is in a better position to be handling objections, either tactically, maybe in terms of overall comfort with the evidence code, et cetera. So I think the issue is that you have more than one person speaking. We would designate in advance that X lawyer is going to be handling objections on this witness.
All right, it's agreeable, but it's going to apply to both sides.
Yeah, thank you.
But it's only one lawyer who's doing the objecting.
Listen to Joe.
Yes.
So if you're doing the questioning, Mr. Przlomiak is doing the objecting, he's the one that's going to be doing the objecting, no objecting by you.
Yes.
And same thing with the defense.
I
Only
mean-
one lawyer can lodge objections.
I've never heard that before. Had
That's
that.
the way it's going to be here.
Okay, whatever you want to do is fine.
So if there's a witness on the stand and decide amongst you who is going to be handling that witness. That lawyer will be the only one lodging objections. There's not going to be any team objecting.
Wait, Michael, stop.
Based on what I just heard, it could be one lawyer doing the question.
Wait.
A different lawyer doing the objecting.
Correct.
Okay.
Joe's like, I've never heard of that before, but okay. So,
Object. Wait, you're sitting next to me. Okay. Oh, Helen, object. Phil, object. I'm handling the witness,
Do you-
and I have to rely on somebody who doesn't know what I'm doing, the reason why I'm doing to object. I have never heard of this before.
it's the weirdest thing ever. Here's my thinking on why John Lewin wants this. He just came into the case, right?
Right.
So he's deferring to, and the guy we heard talking about providing the Cellbrite information to the
Right.
defense, that's lead counsel. That's the guy. I wrote his name down here. It's Ellis. I think I can't remember. And he certainly knows the case better than John Lewin. So John Lewin's effectively covering his ass by saying, I may not be doing the objections during cross because tactical reasons, and I may not know the case as well. That's what he's saying.
But okay, I got it out. But okay, wouldn't it make more sense then if you don't know? Because I've been in that position. I've tried the Spectre case. I was there for like months upon months, okay, and didn't know the code like my co-counsels who are from California. All right, I want to object because I'm handling the cross-examination of a witness. I'm handling it. So I object. And then there's a question of what's the evidence code. You can have somebody else go to the sidebar and say, well, it's under evidence code 4787473042, right? And I'm just making that up, okay? Because I can say why, but I don't know the specific evidence code. But why would it be that if I'm handling a witness and somebody objects to my question, that it has to be the co-counsel that objects? Did I get this right?
No, I've never seen it before. Obviously, Joe Tacopina has never seen it before. And he's like, well, all right, I can't imagine why we would do that. But okay. Speaking of the defense, I read, I did not see her at this hearing, but I read that Camille Vasquez is going to be joining the defense team. Okay, everybody knows who she is, right? Right. I see a lot of heads. I see a lot of heads nodding.
Yes.
Obviously, from the Johnny Depp case, the rising star that came along with Ben Chew in that matter. So I don't know. I don't see her. They have another woman there. I think her name is Sarah Kaplan. She's there with Joe Tacopina. But we'll see if Ms. Vasquez shows up when they get going tomorrow. Anyway, odd at the very
Sarah
least.
Kaplan, a local lawyer, or is she the lawyer that was involved with in the Spectre case and was involved with who was it? Robert. Oh my goodness gracious! I'm having a mental block here. Who was the other lawyers and not Johnny?
I don't know. The name was familiar to me, but I couldn't see her all that well in this shot. So
I can't see it either.
didn't ring a bell to me.
So class, you're the ones who are going to let us know which Sarah Kaplan is it. I may try to text Mr. Tacopino and find out, or Mr. Lewin and find out one way or another, or look her up. I mean, she's probably in the paper file.
I'm sure she's in the California Bar Registry. Yep.
Yeah, and the papers that have been filed, because California puts everything on public, And Missy, there you go. Let us know who's Sarah. Is it Kaplan with the K, Kaplan with the C? There, Missy's going to let us know before, because we're going to be doing this case on a constant basis, right? This is not going away. This case.
Yeah, 15 court days. Interesting. We'll see how that plays out. Let's see if there's any, I think there's not. Let's see what else is in this hearing before we move on.
And when you call a witness, if you want to do the questioning of the witness,
We're still on this.
You want Ms. Kaplan to do the objecting, Ms. Kaplan will do the objecting, but not you.
Or conversely, if I'm cross-examining the witness and I want Ms. Kaplan to do the objections, we can do that as well.
That's fine, yes.
I mean, I don't see that unfolding that way, but okay, thank you.
There's not going to be multiple lawyers objecting to the same witness.
No, I understand.
What a mess.
You know what? It sounds like what's going to happen.
On any
To object. All right, then you just got to handle it all the way through.
I can't wait to see Lewin not object when he's the guy designated not to object.
We gotta pull. You know what we should do is we should pull a couple of clips out of the Durst case.
Gosh. Yeah, he was doing everything there. So yeah, I find it hard to believe Lewin is going to sit back, do an examination, and then during cross just say nothing. There may be a lot of the guy. I tell you again, I apologize. Ellis, I think is his name is. The guy's going to have bruised ribs because Lewin's going to be like this the whole time, jabbing him. Object. What an
Any
idea.
issue that comes up,
Joe said to
any
our
ruling, any decision,
is that Joe is a very hard-hitting lawyer. He's represented Alex Rodriguez in the baseball scandal. He opened himself because we had to give a little synopsis of clients that we represented. He said he had the distinction of representing both now President Donald Trump in one of the federal court cases for sexual assault, and he represents also Al Sharpton in New York for the civil rights cases. Joe's had a lot of clients. He's very good. He's very aggressive in the courtroom. He knows what he's doing. And I can't wait to see Joe Tacopino against John Lewin. This is going to be some show. But the problem is that somebody may have the evidence and somebody may not. Because there's some issues with the evidence, Michael. We haven't talked
There
about
definitely is. It's been, let's see, 3.5 years. Yeah. 3.5 years since this happened. So, yeah, we'll see. You heard him say he had 34 witnesses, but was only going to be calling a few. And so that's why the judge asked him to give me a little paragraph on each of those you think you really will be calling. Okay, let's finish this off. There's not much
I'm
left.
going to listen to both sides, and then I'm going to make a ruling. Once I make the ruling, that's the end of the issue. I don't want to hear from either side, oh, can I be heard? Can I make a record? Can I supplement the record? Once I make the decision, that's the end of the issue. And then we move on. There's not going to be any belaboring.
Understood, Your Honor. We would also request that, I think all counts are going to understand, if there is an area of questioning that in any way, I'll give an example, counsel thinks that the door has been opened with a certain witness. Any question that's going to be asked by either side, where there's any legitimate issue of the court needing to make a determination on relevance 322, et cetera, we want to ask to approach.
Sidebar.
So our position is we can assure the court that if something is close and we haven't litigated it, we'll ask to approach. We usually ask the same
And
on the other side.
the sidebar we do right here. That's Mr. Tacopino.
Yes.
There's a remote there. It's connected to Kathy. She puts on a headset and she'll hear what everybody says.
For sure.
Should add, Your Honor, I'm going to be probably using, I have 2 hearing aids, unfortunately, and I don't hear very well. So during jury selection, I tend to use, it looks like a headphone, but what it is it magnifies the sound so I can hear. So I'm not listening to whatever else is out there, but that'll be on my head during.
A$AP Rocky has a new album coming out.
Oh, so I know.
So anyway, Joe's going to have some fun with John Lewin. I can tell that. I didn't know John Lewin had a hearing deficit. So
yes, he does. He
so
noticed it, but it doesn't about. He's great at dealing with it.
So we'll see what happens. I do think it's interesting. The judge has set some ground rules for objections. No speaking objections. I get that. Unlike Judge Bev, Karen Reed, she doesn't even have state the grounds objections. You've got objection. If I just say objection, that's not really a technically legal objection. That's just me spouting the word objection. If I say objection, hearsay, now you have an objection with the grounds stated. Speaking objections would mean that should come in because blah, 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 but he didn't do that. He did this. That's the speaking part of the objection. And most courts, thank God, don't like that because it drags things out. It creates these arguments in front of the jury. And, so you have a sidebar if you're going to make those arguments. This judge does it the right way, in my opinion. State the objection, state the grounds. And if we're going to have a sidebar about it, yes, we will do that. So,
yeah.
So that's what's happening.
Can I just say that I think Sarah Kaplan was also in the Phil Spector case?
Well, it wouldn't surprise me. Yeah.
Right now,
It's
kind of fun. It's so much fun when I can comment on cases that I'm not involved with, but I know a lot of players.
Yeah. So do a deep dive on her since the name is so familiar. I'm sure folks have a clue.
Yeah. And anyhow, but can we end this segment by talking about the main part of the, well, it may not be main, according, depending on how the prosecution plays it, but there's a video apparently of or around the time of the shooting, about the shooting, where it shows a man whose face isn't visible. He's in a hoodie or a hooded sweatshirt, as they say, appears to be holding a firearm, which is supposedly a semi-automatic firearm, and then runs around the corner, and supposedly that's the shooter. I think, having not heard the opening statements. So
we shall see. Again, jury selection kicks off tomorrow, and it'll be quite the fun adventure to follow. They'll be in that courtroom tomorrow for the jury, 102, and then they'll be moving to the other courtroom, I'm guessing a smaller courtroom, when they actually try the case. Okay, Georgia versus Jacqueline Johnson. What is going on here? It's a throwback to Ahmaud Arbery.
now let me have another disclaimer. So when I'm at the Harvard Trial Advocacy Workshop again, as you know, in the Arbery case, where the defendants were convicted, both federally and state, the representation of the victims, families representation, obviously Ben Crump had, and I believe he had the main representation of the decedent. Also Lee Merritt, who I was, another attorney, civil rights attorney, was there. You'll see a picture of me. I put it on Instagram, hiding nothing. He is also, in the trial advocacy workshop, good attorney. In fact, we were in the same group teaching people. And also, I just want to throw that out there. And the attorney who represented one of the defendants in that case, not this defendant, not Jacqueline Lee Johnson, is somebody also who's a friend of mine who I taught with down in Georgia when I taught. Essentially was a public defender type of group before the pandemic. So I just want to put that disclosure on.
All right. Let me make a note of that. Okay. So what's going on now? And I was down there for the Arbery case. It was crazy. It was, it was emotional, and it was loud. And when these guys were all convicted, and by the way, that was Travis McMichael, Greg McMichael, Roddy, Brian, all convicted in the death of Ahmaud Arbery. We know the video. It's outrageous, difficult to watch. So now we have the prosecutor at the time, Jacqueline Johnson. She was the DA at the time. For the way they do it is by district, and she was the DA for the Brunswick Judicial District, which is part of Glenn County. She is now being accused of effectively looking the other way, felony looking the other way. The two official charges are violation of the oath of her office, in that she chose to favor Greg McMichael. And then the second charge, that first charge is a felony, by the way. The second charge is a misdemeanor obstruction and hindering, because she told a couple of deputies not to arrest Travis.
Right.
So let's do this to kind of set the groundwork for this, because it is really all about her relationship and the department's relationship with Greg McMichael. Let's look at the body cam footage where Greg McMichael is first talked to on the scene by the detectives, or I'm sorry, the deputies. And remember this setting. Here's the white truck. We'll see, very familiar. Just off camera is, and not shown, is the body of Ahmaud Arbery. Behind this cop is Travis McMichael being interviewed by somebody else. So just to give you the physical nature of that setting, and then we'll talk about what has gone on since.
Okay.
Okay. What did you see anything?
Here's what precipitated the whole thing. I'm standing out here working on my boat cushions in the back of my truck.
Where's your
Right over here, 230.
Okay.
Right here. This guy, who we've seen on video numerous times breaking into these other houses, he comes hauling ass down the street. I mean, he's got it hooked up.
Was he on foot?
On foot.
Okay.
On foot. I mean, he ain't jogging. He's hooked up. I run in the house. I said, Travis, the same guy that broke in the house down there.
Who's Travis?
My son got shot.
Okay.
I said, come on, let's go. So Travis runs and gets his shotgun, because the other night, the guy stuck his hand in his pants. And so I grabbed my step back. It's an old Glenn County PD issue, by the way. And so we take off. I jump in. So we can't move it, don't have time to move it. So I kind of sit on top of it. We see him come around the corner. He's going down here. We pull up beside him. Hey, stop, we want to talk to you. And he just keeps on running. And he's looking at us. I mean, we're this close to him, you know. And he keeps on running. And then Roddy pulls out at some point. I don't remember exactly.
Is it Rodney?
Roddy.
Roddy?
Roddy.
Where was he?
I don't know. He lives down the street here somewhere.
Okay.
Anyway, he pulls out. We already passed this house. I think he lives the second house down there on the left. Anyway, we already passed this house. The guy turns around and he starts running back this way. Roddy pulls out in his truck and kind of blocks him. So I said, Travis, go back that way. He said, no, I'm going to go head him off. So sure enough, he comes around. We come back down here and he's right here. And he starts running past us. Travis backs up and says, hey, stop. We want to talk to you. Or something to that effect. I don't remember exact words that was said. By this time, I'm in the back of the truck. So the guy, I mean, he's looking dead at us, you know. I mean, he's like, from me to you. And he turns and he runs. Travis gets out with the damn shotgun and runs up there. And, you know, I said, Travis, don't shoot. Don't do anything. The guy turns and comes at him. And they start wrestling, and Travis shoots him around the damn chest. The guy was trying to take the shotgun away from him. He's got a little video.
Okay. All right. Do me a favor, hang tight.
Yeah, I ain't
Let me go.
I would like to get his blood. I rolled
I
him
understand that.
to check his pulse.
Yeah.
Or didn't roll him. I pulled his head out because he had his hand stuck up under his head. I pulled his arm out, and then I realized he didn't have anything in his hand, and saw that this ain't gonna last long. So is there any way I can?
Yeah. Give me just a second.
Sure.
Let me get some pictures and stuff like that,
Sure.
and we'll get everything
Here,
taken
you
care
go
of.
right
Okay. Give me just a minute.
You know, I was chief investigator with the DA's office for
Okay.
23 years, so I know what you got to do. I know everything. You know.
Yeah. We're just you know
Cover
kinda
all
take our time.
the basics.
Exactly.
Absolutely. We're here to help.
All right. Give me just a second.
Okay, so I was chief investigator with the DA's office. He throws that in at the end there. 1 hour after that body cam interview, he picks up the phone and he calls the defendant, in this case now, Jacqueline Johnson.
Right.
Okay, and again, at the time, the DA for his district. So it really began from day one, this problem with her not doing her job and now facing misconduct charges as a result. You know, I see this for the first time in a while, and you know, a number of things strike me. You know how he was not jogging. You know, already looking, you know, at that defense, right? Because people would say the guy's wearing tennis shoes, and he always jogged through that neighborhood.
Right.
He talks about, we got him on video. You know, look at, well, yeah, there was video of him in a vacant home that was being built, and it was just, I would do the same thing, to be honest with you. I've gone, I'm just wandering in. I'm curious about construction and stuff. He didn't take anything. There's no evidence of that. And then he's trying to take the shotgun away, you know, from Travis. So as early as that statement, he's laying the groundwork.
Right, trying to take it away because he knows they're going to kill. They're trying to kill him. I mean, we do the same thing, right?
So
that gun.
So he calls her up and basically saying, hey, you know, there was a shooting. I got to have some help. Let's look at the indictment, okay? Because that gives us a sense of, you know, the very specific events that the prosecution believes relate to this, these two charges. And there are two charges. One is the count here, violation of oath of a public officer. Let's go down and look at the exact events that caused the problem here. On or about February 23rd, 2020, the accused, again, Ms. Johnson, violated her oath. How did she do that? By showing favor and affection to Greg McMichael during the investigation into the shooting death of Ahmaud Arbery. And if you go down a little further here, it says that the defendant in the Arbery case, Greg McMichael, sought the assistance, as did this DA, of Waycross Judicial Circuit District Attorney George Barnhill. Who's he? Barnhill? He's the guy that replaces Johnson. She reaches out within a few days of the case and says, I got a conflict here because this Greg McMichael worked in my office, right?
Right.
So how do they fix that? They go to this George Barnhill. He's put in place, and he's there for a while, and then he recuses himself as well. A number of reasons that will become clear at this trial. One, I think his son worked with Greg McMichael on some matters. But more importantly, when Johnson puts up Barnhill to take her spot, she doesn't disclose that the said accused, Ms. Johnson, had previously sought the assistance of DA Barnhill on the case. And so, I'm sorry, the accused in this reference is Greg McMichael. He reaches out to Barnhill and asks for help. So he's already got Barnhill involved in this process. Johnson doesn't seem to care, know, or ask the right questions, appoints this guy to take over the case. So those are the two issues that relate to count one. Now, count two, far lesser, but, still, if true, is just plain wrong.
Maybe even easier to prove.
This is just the obstruction and hindering. And so you're going to hear from Officers Stephanie Oliver and also Stephen Lowry. These are law enforcement officers, quote, with the Glenn County Police Department in the lawful discharge of their office official duties. She directed that Travis McMichael should not be placed under arrest, contrary to the laws of the state, blah, blah, blah. So those are the two charges. That's the case. One is felony and one is misdemeanor. So, she could be incarcerated for this. Who knows? Obviously it's a case of, her first record. There is no record of any other issues. Who knows? Maybe something will come up. But we don't believe there are any other issues. So she may or may not do time. But is it right? Is it wrong? That's what they're going to find out by jury trial beginning tomorrow.
She's doing that allegedly because she's trying to give him a favor. I mean, you can say don't place somebody under arrest because you think there needs to be further investigation, which I assume that they're going to say, or because, hey, they worked in my office, their dad worked in my office, we have relationships with them. Don't place them under arrest because you just don't do
Or
that.
you don't say it. And I think it'll be interesting at trial to see if there's anything that hardcore. If there's a smoking gun, so to speak, a document, a witness that says that was the reason she used, don't arrest him because I'm doing a solid for his dad and the family. That's dead bang, loser for the defense. But maybe it's a little vague and it's not all that clear. So that'll be interesting to see how it unfolds.
Think any chance of possibility of a, as they called it in California,
Settlement
as opposed
settlement.
to
I don't know. I don't know. Guess who's representing her?
Who?
Brian Steele.
Wow, you didn't disclose that little fact.
I didn't tell you that. Oh,
no, you didn't tell us that at the beginning.
Yeah, Brian Steele's very busy. Oh, and this is another interesting thing. Remember, this happened February 23rd, 2020.
Right.
He was indicted in September of 2021, right?
Right.
So you may be thinking, well, this is not exactly a capital case. Why would it take so long to get this thing to trial? It's the YSL factor. Because Brian Steele was tied up in the YSL case, he couldn't do this case.
Isn't that interesting?
Yeah, and so now that he's out of that case, he can bring this one to trial. So,
well, we're gonna obviously keep following this. We're gonna try to in the future starting to try to get people that are actually involved in these cases on the show. Part of the problem is sometimes they don't want to come on because they're in the middle of the case. But unlike maybe criminal cases, we do have people coming on show tomorrow, right? We do have a show tomorrow.
Oh yeah, I almost forgot. We have tomorrow. We have the I'm calling it the Algonquin Live Roundtable of Fulton County and beyond, really, right?
Right.
We have not just Doug Weinstein, who we love, not just Ashley Merchant, who we love, but both at the same time.
Both at the same time. Ashley Merchant. Call it Fani Willis's worst nightmare.
Yes.
Today, President Trump was sworn in. We'll see if there's been any movement between today and tomorrow because things seem to work fast in the case. But there was a number of things that happened last week, a number of decisions by the courts that we're going to talk about. I mean, it's going to go so fast. And of course, Doug, you all know, and his client, by the way, who he's not representing in these new matters, but not the new matters, they're kind of like old matters that we believe the state is using to keep Yak Gotti in jail because as retribution. But that's just my bent, being a criminal defense attorney. It may not be true. He's going to be talking about that. And with Ashley, the two of them that have gone against Georgia. And now we have Brian Steele that's going to be in this next case. Not on tomorrow, but hopefully soon.
Isn't it crazy? And Pee Wee Roscoe, part of the YSL gang, he was just finally released. Remember, he took a deal back in December but he stayed in jail, not unlike Yak Gotti, because he had some other things happening. In this case, something else going on in Florida. But that's been resolved, and he's now out. So we can find out what the deal is with Yak, because remember, Bruce
Harvey.
Thank you. No, Bruce Harvey, yes, and Nicole Westmoreland, right?
Right.
They took over defense, and they had a hearing, but couldn't do anything about it because of alleged conflict between the new representative attorneys and others in the case. So until they learned whether or not there was a true conflict, they pushed that till February. And that original motion, which the judge, in my opinion, didn't have the stones to make a decision on, that was pushed to February. So Diamante Kendrick still in jail, as far as we know. But tomorrow we will get the latest on all of that. So don't miss things tomorrow. What time are we doing that? 6 o'clock.
At 6 o'clock, it's 6 to 6:55. But Michael, you didn't mention that I'm kind of Barbie-ish today.
Oh no, I didn't notice that. Is that a Chanel jacket?
It's actually the one, not the one, but the one that was worn in the movie. It's the same one. It's not the one she wore, because she's probably about 10 sizes smaller than I am. Yeah.
I don't know.
Nails that kind of
So
match.
what's the occasion?
Well, Wednesday I am speaking in front of a major law group about the Truth and Justice Project by my jury consultant, Richard Gabriel. There's going to be the chief judge of the court in New York, one of the courts in New York going to be on, another judge, a bankruptcy judge, federal bankruptcy judge, defense attorneys and all, and that's for Wednesday. So I'm getting prepped early, because I have to not embarrass us. When they first booked me, it was not only as a high-profile defense attorney, but it was as an anchor for Law and Crime. But now I've asked them to change that as the co-anchor. Actually, I asked them to put co-anchor, co-executive producer of Justice Serve TV. And I don't want to embarrass you.
I appreciate that. Let me see those. Let me see those nails close up there. Do you have like things on there?
Yeah, and they were painted to match the jacket. If you see.
Oh my gosh.
Look at that, a true artist.
All right. Well, good luck keeping that whole ensemble under control for 2 days. and I don't know what's happening Wednesday to be sure, but maybe Bob will come on. We'll see while you're doing your thing. We'll see. We'll see what else is happening.
Definitely won't be here on Wednesday, but I'll miss you all. But I will see you tomorrow night.
Yeah, tomorrow night. Make a note. 6 o'clock tomorrow night, live with Ashley Merchant and Mr. Doug Weinstein. So,
Yeah.
in the meantime, what else? You got anything else?
So, yeah, if you're having a problem like I am, I do not get notified no matter what. Complain to YouTube, because if I'm not getting notified, what about our near 4,000 subscribers? Because I'm one of them, and I'm still pressing that subscribe button, and I do not get notifications when we go live at all.
Interesting. I do, and thank goodness, because otherwise I'd forget. So I'm glad I'm getting a notification myself. Okay. Are we good?
Yeah, thanks to our producer, Missy Mayhem.
Yes.
Appreciate it. No, we're good. You're on.
All right, then until next time, I'll try to do the right thing. We'll see you.
And I'm Linda Kinney Button. Together, Michael and I are Justice Serve TV. Hit that subscribe button, like, share, and notify. We'll see you next time.